Well, thank you again. And as Professor Gadic kindly mentioned, now we will look into the loss of mutual trust as a ground for recognition and enforcement. And to do so, we will in particular refer to the problem and use as a problem analysis the example of the judiciary crisis in Poland. Now, you may be informed that between 2015 and 2017, the Polish executive and legislative authorities adopted more than 13 laws affecting the entire structure of the justice system in Poland. And by doing so, they systematically and progressively dismantled the major checks and balances of the Polish state on the one hand, and they subordinated the courts, the civil service, and the media to the will of the executive. This triggered a reaction in December 2017, which has taken the form of the European Commission's reasoned proposal for a Council decision on the determination of a clear risk of a serious breach by the Republic of Poland of the rule of law. This is almost unprecedented. I should like to point out that, well, this was the first reaction on behalf of an institution of the European Union. It has been followed very significantly by the reaction of both national courts and the Court of Justice of the European Union, in some instances on request of the European Commission itself, in other instances of request of Polish courts themselves, to try and reestablish to some extent, or maybe not really reestablish because that would not be the case, but to try and at least emphasize the lack of democratic process that these 13 laws have triggered. I should also like to point out that in this case, Poland is being used as an example because of the wealth of information at this point we can rely on, especially taking form in not only the reasoned proposal of December 2017, but also the series of decisions that were rendered by the Court of Justice. But unfortunately, regretfully, of course, this is not the only case. And the other case being, for instance, Hungary, which is also has been brought before the Court of Justice of the European Union in a case which is to some extent actually significantly similar to the ones that relate to Poland. I should also like to point out that, of course, here you see I am mentioning a reasoned proposal for a Council decision, and the question that arises is, well, what has Council done? Council has actually done a lot, I believe, possibly more behind closed doors than in open public, given the sensitivity of this matter. You may wish to know that I double-checked yesterday again the last let's say, active action that Council has taken dates back to January 16th of this year, where Council met to discuss again this proposal. But I'm sure that a lot is going on in the meantime, and perhaps there is hope also that the judgments rendered by the Court of Justice will have an impact and try to change the course of this situation. Allow me. Yes. I mentioned several times a reaction of the judiciary, both national and the Court of Justice of the European Union. In March 2018, an Irish court handed out a judgment in a case which, under normal circumstances, would actually raise no surprise. It suspended a drug trafficker, a Polish national, a suspected drug trafficker, a Polish national, was sought in his home country, Poland, under the European arrest warrant. So, per se, this is not big news. You, of course, may know that the European arrest warrant is the first concrete measure implementing mutual recognition between member states in the area of judicial cooperation in criminal matters. We will refer back to civil matters later. The mechanism of the European arrest warrant is based on a high level of mutual trust between member states. Its implementation may be suspended only in the event of a serious and persistent breach by one member state of the principles set out under Article 2 of the treaty establishing the European Union, and in particular the part where the provision states that the Union is grounded on the rule of law. And this is paramount in all the discussion before the Court of Justice. The Irish court refused to authorize extradition and made a reference to the Court of Justice for a preliminary ruling. In doing so, the High Court observed, and I quote, that the rule of law in Poland has been systematically damaged by the cumulative impact of all the legislative changes implemented in the previous 2 years. Such changes amount to a clear risk of a serious breach by a member state of the values referred to in Article 2 of the Treaty on the European Union, and in particular, a violation of the individual's fundamental rights to defense and fair trial, established at Article 47 of the Charter on the CFREU, Charter on Fundamental Rights of the European Union, and Article 6.1 of the European Convention on Human Rights. So the High Court referred the question to the court, and the court actually, if I may, could not have agreed more. It is of interest that in paragraph 48, the court stated, of course, that judicial independence is part of the essence of the fundamental right to a fair trial under Article 2 and, of the Treaty on the European Union, Article 47, and then Article 6.1. Now, this may be seen as predictable statement, but this is actually the core of how the Court of Justice takes power in a way over something that under different circumstances could be construed as a purely national situation. What the court also does at paragraph 63 is state that the requirement of independence entails that the court concerned exercises its functions wholly autonomously, without being subject to any hierarchical constraint or subordinated to any other body, and without taking orders or instructions from the source, from any source whatsoever. So the idea is, if you have a judiciary that is under constraint, control, or any kind of intimidation by the legislative and executive branches, that judiciary will likely not feel at ease in judging impartially. That will have an effect, and a very negative effect, on the judgments that are rendered by that judiciary. And this is in clear contrast with what established under Article 2 on the Treaty of the European Union, and the fact, in particular, that the European Union is grounded on the rule of law. So this is actually the mechanism whereby the Court of Justice ties into what a matter that under other circumstances, although regrettable, and one may construe it as significantly anti-democratic, could be, however, interpreted as being a purely national matter. This is the landmark decision. You may wish to know that as a result of this decision, the High Court refused to execute the arrest warrant. But this is also the landmark decision for all the decisions that followed, rendered by the Court of Justice of the European Union. Among these, and again, it is of interest that these other decisions have all been rendered this year. This one that I'm going to mention now was rendered on June 24th this year, and then there is one rendered on November 5th, and one rendered 2 days ago. Now, In the next two decisions, you will see that the European Commission itself took a stance and brought the question before the Court of Justice of the European Union, asking in particular in this case whether, and the court actually agreed. I will just skip and go directly to what the court stated. The court stated that by lowering the retirement age of the judges of the Supreme Court for judges appointed before April 3rd, 2018, and especially by granting the President of the Republic the discretion to extend the period of judicial activity of Supreme Court judges beyond the newly fixed retirement age, the Republic of Poland has failed to fulfill its obligation under Article 19(1) of the Treaty on the European Union in the part where it states that member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by Union law. And this is the first case where the European Commission itself takes matters in its own hands and tries to counteract to the actions undertaken by the legislative and executive branches in Poland from an EU law perspective. Similarly, in the decision rendered on November the 5th, and again, the ruling is a result of a request submitted by the European Commission, building on its previous case law, the Court of Justice ruled that the Polish law establishing a different retirement age for men and women, and I will make it short here, is actually a discrimination based on gender, and it does not comply with equal treatment of workers. The same law, in granting the Minister for Justice the right to decide whether or not to authorize judges of the Polish courts to continue to carry out their duties beyond the new retirement age, is in breach of Article 19(1) again. So you see, also in a matter which apparently is discrimination, which of course is important based on gender. However, again, the problem here for the rule of law and the impartiality of the judiciary arises again with respect, of course, to the power that the other two branches are exercising over the legislative branch. And 2 days ago, actually, here we see the Supreme Court of Poland reacting and trying itself to take a stance against what's going on. So the Polish Supreme Court actually asked the Court of Justice to look into this case, and the result, the statement of the Court of Justice is that Article 47 of the Charter must be interpreted as precluding cases concerning the application of EU law from falling within the exclusive jurisdiction of a court which is not independent and impartial tribunal within the meaning of the former provision. What happened was that actually the executive branch had established a specific chamber within the Supreme Court and had allocated jurisdiction over certain cases exclusively to this court. However, this court was not established impartially because it was the result of a discretionary appointment by the executive. So what the Supreme Court of Poland was reacting against and seeking, of course, for support was exactly, is this in compliance with EU law, or can we disregard that exclusive jurisdiction, the exclusive jurisdiction established by the legislative and executive branches with respect to those cases? And what the Court of Justice 2 days ago did was respond in the affirmative. Again, this is a sweeping statement, meaning that, of course, the Court of Justice cannot say exactly what the national court has to do, but what the Court of Justice stated is that if this is the case, and you, national court, have to verify that this is the case, then indeed this is in breach of EU law, because that chamber was not set up in an impartial manner. I have discussed up to here we have discussed about judicial cooperation in criminal matters with the European arrest warrant, and we have seen also cases of reactions by the institutions and by the national courts themselves. However, the topic of our discussion here relates more to civil and commercial matters. As a disclaimer, I would like to say that the judgment that I'm about to present, as I mentioned earlier, is a judgment where recently, in July 2018, the German Supreme Court refused to recognize and enforce the Polish judgments on the grounds of substantive public policy and on the grounds that the measure ordered by the Polish court, the Court of Appeal of Krakow, actually clashes with the defendant's freedom of expression. I would like to emphasize that nowhere in its judgment the German Supreme Court states that its reaction is the result of the judiciary crisis in Poland. This needs to be made clear because I don't want to create wrong assumptions. However, this has been construed by some commentators as being part of a reaction, being part of a kind of suspicion to some extent against decisions rendered by Polish courts, even in matters that certainly are less sensitive, inevitably, such as those in civil and commercial matters, compared to the ones per se they're very sensitive, of course, but compared to the ones that we just discussed, they have a different impact on the whole picture of a legal system. So, the German court did not use the crisis of the judiciary in Poland as a reason for refusal of recognition enforcement. However, it is also true that, and this also has been a reading given to the reaction of the German Supreme Court, that the German Supreme Court did not even make an effort to adapt and we go back to adaptation here, to adapt the foreign unknown measure that was actually ordered by the Polish court. And again, perhaps this could be the result of keeping distance from this judgment as, to some extent, perhaps a matter of principle. This is a question of interpretation. Again, the court did not use this as a ground. But the court actually gave us a really interesting example of how perhaps member states were correct in refusing to relinquish public policy as a ground for refusal of recognition and enforcement. If time allows, I would like to walk you through the judgment because it's actually interesting. In 2013, the ZDF, one of Germany's main public service television broadcasters, referred in a documentary to the concentration camps situated in Poland as, and I quote, Polish concentration camps. Following a complaint by the Embassy of the Republic of Poland in Berlin, the ZDF changed the text of the announcement to German concentration camps on Polish territory. At the same time, the plaintiff, a Polish citizen and former prisoner of the concentration camps, complained to the ZDF, claiming that his personal rights had been violated and demanded, among other things, the publication of an apology. The ZDF did indeed apologize to the plaintiff in 2 letters and expressed its regret. In spring 2016, it also published a correction message expressing its regret for, and I quote again, it's the careless, false, and erroneous wording and apologizing to all the people whose feelings had been hurt as a result. So it actually went, if I may, the extra mile to try and correct its inappropriate and hurtful and inappropriate behavior, conduct. At the end of 2016, on the basis of an action that he had brought in Poland in 2014, the plaintiff obtained a second instance judgment from the Court of Appeal in Krakow, requiring that the ZDF publish an apology on the homepage of its website, not just anywhere on the website, for a period of 1 month, expressing its regrets that the announcement from 2013 regained, and I quote, "incorrect wording distorting the history of the Polish people." The ZDF published the text of the judgment on its homepage from December 2016 to January 2017, although only via link. The applicant considered this as inadequate, and it sought to have the Polish judgment enforced in Germany. The two lower courts in Germany agreed with the plaintiff, whereas the German Federal Court, Federal Supreme Court disagreed. Referring to Article 45 of the Brussels I regulation, because that was applicable ratione temporis, but of course this doesn't make a difference with respect to the public policy exception, the court held that the enforcement of the judgment would result in a violation of German public policy, because the exercise of state power to publish the text of a judgment prepared by the Krakow Court of Appeal would clearly violate the defendant's right to freedom of speech and freedom of the press, as embodied in Article 5.1 of the German Constitution. The court clarified that the dispute at hand did not concern the defendant's original announcement, which was indeed incorrect, but only the requested publication of a pre-formulated text. This text, which the ZDF, according to the Krakow Court, had to make as its own statement, and this is where the problem lies, represented an expression of opinion. And to require that the ZDF publish a text drafted by someone else as its own opinion would therefore violate the ZDF's fundamental rights under Article 5.1 of the German Constitution. So, on the one hand, here we have a clear example of substantive public policy as a ground for refusal of recognition and enforcement in the area of civil and commercial matters. On the other hand, again, the reading that has been given of this judgment is that it may be the result of a certain discomfort towards the judiciary, and to no fault of the judiciary, of course, but the judiciary of the court of origin. The problem certainly doesn't lie with the judiciary in this case, to the contrary. What has been also noted, and I mentioned earlier, is that however, the German Supreme Court did not make an effort to try and adapt the foreign measure. It is true that the foreign measure per se clashes with fundamental value under German constitutional law. However, it has also been observed that the German court, could have redrafted, tried to adapt the foreign measure into a measure that it knows under its own law. And for instance, it could have redrafted to some extent the order by asking the defendant, ZDF, that it publish the following statement. According to the judgment of the Appellate Court of Krakow, the ZDF is required to publish the following decision. This is a measure that is commonly actually ordered, I seem to understand, by German courts, and to the extent possible, and you may remember that this is actually the wording under Article 54 of the Brussels I regulation, this would have satisfied the possibility of adaptation and assimilation. It would have been a step forth towards mutual trust. Just a last reminder, I mentioned that this case is governed under Brussels I regulation, which means, of course, that Article 54 doesn't apply because it doesn't exist. However, as I mentioned earlier, it doesn't exist in the Brussels I regulation. However, as I mentioned earlier, the Court of Justice in DHL, Express France, and other judgments had indicated that it is common practice under procedural law to proceed with an assimilation of a judgment or unknown measure where possible. Again, some selected readings, and I've put a hyperlink to the decisions that I mentioned, and I thank you for your attention.